Hello friends, in this video we will cover a very interesting topic around which the company law revolves, that is director. Let us know the meaning of word director in layman's language. A director may be defined as an individual who directs, controls or manages the affairs of the company. A director is a person who is appointed to perform the duties and functions of a company in accordance with the provisions of the Companies Act 2013. They are collectively known as Board of Directors. As per Section 2, subsection 34, director means a director appointed to the board of the company. Coming to Section 2, subsection 10, Board of Directors or board in relation to a company means a collective body of the directors of the company. They play a very important role in managing the business and other affairs of the company. Appointment of directors is very crucial for the growth and management of the company. As per Section 149 of the Companies Act, every company shall have a board of directors consisting of individuals as directors. It is clear to understand from this line that only an individual can be director of the company. Some persons have doubt that other than individual can be director or not. But according to this section, only an individual can be director of the company. The board shall consist of individuals, not of other persons like firms, LLP, companies. The directors or collectively you say board of directors are primarily responsible for determining the company's strategic objectives and policies, monitoring progress towards achieving the objectives and policies, appointing senior management, accounting for the company's activities to relevant parties like shareholders. Coming to composition of board of directors. The Companies Act 2013 fixes the minimum and maximum number of directors a company can appoint. Under the 2013 Act, a private company is required to appoint at least 2 directors, while a public company must appoint at least 3 directors. And a one-person company is required to appoint at least 1 director on the board. A company can appoint a maximum of 15 directors, wherein a maximum of 12 directors were allowed under the previous act, that is Companies Act 1956. It is possible for a company to increase the number of directors beyond 15 just by passing a special resolution to this effect. Moreover, one of the directors of the company must be resident in India, that is, he must have stayed in India for a period of not less than 180 days in the previous calendar year. Coming to maximum number of directorships. This point does not form part of composition of board of directors, but it is from individual director point of view. The maximum number of directorships a person can hold is 20. Further, in that 20 companies, the person cannot be a director for more than 10 public companies or private companies which are either holding or subsidiary of a public company. Now let us delve into the section 166 of the Companies Act 2013 that stipulates the duties of the directors, which are as follows. A director must act in accordance with the articles of association of the company. A director must pursue the best interest of the stakeholders of the company in good faith and to promote the objects of the company. A director shall use independent judgment to exercise his duties with due and reasonable care, skill, and diligence. A director should always be aware of conflict of interest and should try and avoid such conflicts for the interest of the company. Before approving related party transactions, the director must ensure that adequate deliberations are held and such transactions are in interest of the company. To ensure vigil mechanism of the company and the users are not prejudicially affected on account of such use. Confidentiality of sensitive proprietary information, commercial secrets, technologies, unpublished price to be maintained and should not be disclosed unless approved by the board or required by law. A director of a company shall not assign his office, and any assignment, and if so made, shall be void. If a director of the company contravenes the provisions of this section, such director shall be punishable with fine, which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. Coming to penal provisions, the Companies Act has various penal provisions to ensure proper adherence to the duties and responsibilities laid out under the Act. The idea of officer who is in default has been stipulated under lapse in duty in the circumstances that the officer is in default for any provision of the Act and is part of such contravention, either self or participation without objection, shall be liable to penalty or punishment, including imprisonment. The director under scrutiny here can also include nominee directors. The matter is very sensitive, as even if the director is not part of such meeting but has received the information of contravention in any form is liable and can be held party to such act. Hence, it is very important that the voice of objection of the director needs to be mandatorily recorded to avoid any such implication on innocent person. The penalty amounts applicable under Companies Act 2013 are more higher in denomination and very stringent compared to the Companies Act 1956. Proven defaulter on section 166 can be fined anything between 1 to 5 lakhs. Under the Companies Act 2013, certain defaulters can attract imprisonment, mostly non-cognizable. However, offences connected to fraud or intent to fraud are cognizable, which means no warrant required for arrest. Likewise, suppressing any material information or furnishing false information is cognizable. Providing misleading statement in the prospectus, inducing fraudulently for investment is cognizable. Transfer or transmission of shares with intent to defraud and offences related to reduction of share capital are cognizable offences. In Companies Act 2013, shareholders or group of minimum 100 shareholders on behalf of all affected parties can bring class action suit against the company and the directors for any wrongdoing. This will be taken up by National Company Law Tribunal. In addition to the Companies Act 2013, lots of other acts are interrelated and can attract penal action based on multiple conflicts. So, the director needs to be aware of the interdependencies of different laws and how they can influence the decisions they are going to implement. Now, coming to liability of the directors. The liability of the directors can be both joint or collective for any and every act prejudicial to the interest of the company. Though the director and the company are separate entities, under the following cases, the director may be held liable on behalf of the company and may attract legal proceedings. The cases could be number one, tax liability. Unless a director or any past director can prove that the non-recovery or non-payment of taxes are attributable as gross neglect or breach of duty, then any present or past director will be liable to pay the shortfall in tax amount and any penalty associated. Next one is refunding of share application or excess in share application money. Next one is to pay for qualification shares. Next one is civil liability in case of misstatement in prospectus. Next one is fraudulent business conduct and all associated debts and contracts executed. Next one is failure in making disclosures as stipulated by SEBI. In addition to these liabilities, some criminal liabilities also associated with directors' conduct, like checks bounced or dishonored. Under Negotiable Instruments Act 1881, signing of dishonored by a director may lead to prosecution along with the company. In addition to this one, offences under Income Tax Act 1961, offences under labor laws, especially in case of Employees Provident Funds and Miscellaneous Provisions Act 1952 and Factories Act 1948 considered as serious criminal liabilities. Derivative action is defined as an action by one or more shareholders of a company where the cause of action is vested in the company and relief is accordingly sought on its behalf, though it must be brought in a representative form. A shareholder may bring an action against the company and its directors in respect of matters which are ultra vires, the memorandum or the articles of the company, and which no majority shareholders can sanction. Directors and the company would also be liable if the conduct of the majority of the shareholders constitutes a fraud on minority. That is a discriminatory action. To safeguard the interest of the company, any member or members may bring a derivative action. The liability of any or all of the directors of a limited company can be unlimited if so specified in the memorandum or approved through a special resolution authorized by Articles of Association. Any and all provisions provided in Articles of Association to indemnify directors against default, negligence, breach of duty, or trust is void as per Companies Act. However, in case innocence of the director is proven, such indemnity can be enforced. Hence, this is a very important clause for directors and one should always be aware of and try to utilize this to the maximum benefit possible. The Companies Act allows a company for taking insurance for protection against loss caused to it by directors. Also, the director can take insurance policy to compensate for loss incurred due to liability of the company for which premium can be paid by company itself. To conclude all this, it is not that difficult to adhere to if the directors are fulfilling their duty in the best interest of the stakeholders. The directors needs to be more prepared now than before to avoid any grave circumstances against them or against the company. They should attend as many board meetings as possible and should be fully aware of the company's business. They need to come very much prepared and alert before joining a board meeting. Only participation in meeting is no more enough. It also needs to be ensured all questions or expressed dissents are properly recorded in the minutes of the meeting. This is extremely important and is pertinent evidence about the legal hassles at a later date. Proper training for directors on corporate governance is necessary and will equip them to work in the best interest of the organization. It needs to be ensured by self that the directors are not remaining unadvised. However, knowledgeable or experienced someone may be it will be prudent practice to legal advice in case of doubts or critical situations. Directors' liability insurance is very important for directors now. The Companies Act 2013 has very well played its role in enacting corporate governance in the very core of the company system. However, more than adherence to purpose, it relies on adherence for survival, which may fail it someday like all previous amendments. It needs to be more straightforward while assuring stakeholders' interest. Fear may allow necessary shield to hold the corrupt people for some time. However, it will not be long that bypass to such rules that are already being invented. Corporate governance needs to be imbibed into the soul of the system through tangible benefits to the followers. Only then it will become the goal of the companies and will be followed religiously. The best thing is all stakeholders and shareholders of the companies have faith in the Companies Act. If you liked the video, please subscribe to our channel. Happy learning. Thank you.